Yes. Yes.
Mbona anakodoa macho?
Shika kamera isiangu.
Kuvuruga hawa watu wanakuwa wajue tuko kazi. Jaribu kuinua kichwa wewe.
Present, John.
Miss Sonia
Present, Your Honor.
and Mr. Jackson Macaulay.
Present, John.
IPOA is represented by Ms. Christine. Afternoon, Your Honor, I'm present.
Dan Samamai, Mr. Clifford Beta, Mr. Yegon,
Present, John.
Mr. Langat. There are two Langats.
And it's Philip Langat.
Philip Langat.
You're not present the last time, or you're present?
I was not present.
Okay.
He was in the quorum.
Okay.
Sent him to do another matter. Mr. Kangai. Present.
Good afternoon, I'm present.
Mr. Stanley Punejui.
Present, Your Honor.
Mr. Geoffrey Langat. There are two Langats.
Present, Your Honor. Present.
Mr. Kipton Philip.
Present, Your Honor. Felix.
Yes, present. And Mr. Vincent Yegon. That's the team for the transport. Before you read the ruling,
Yes.
there is a preliminary issue that we wanted to put to the court. It's only 2 minutes. Only 2 minutes. We are not making an application to arrest the ruling. It is just a small concern.
It's okay. Yes,
Thank
any Mr.
If not, then we proceed with the ruling, then they can make the application.
Yes, if
The
he
only
does
way
it
to stop the ruling would be to arrest it.
No, we are.
of the Constitution of Kenya 2010. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amount to interference with witnesses, an impediment to or perversion of the course of justice. If the interference is aimed at impeding or perverting the course of justice, and if it is so found, it is a justifiable reason to limit the right to liberty of the accused. End of quote. I've also cited the case of R versus Pacius Gishobi that affirmed that the proven interference with witnesses is an affront to the administration of justice and therefore a compelling reason as contemplated by Article 49, Sub-Article 1H of the Constitution. Accordingly, the specific instances of or likelihood of interference with witnesses must be laid before the court with such succinct detail or evidence in support thereof as to persuade the court to deny the respondent bond on this ground. It was initiated in the case of R versus Dwight Sagary. I've quoted here up earlier, Supra, and I quote, "For the prosecution to succeed in persuading the court on this criteria, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of threat or threats to witnesses, direct or indirect, incriminating communication between the accused and the witnesses, close familiar relationship between the accused and the witnesses, among others." End of quote. It is therefore incumbent that the prosecution needed to demonstrate with tangible evidence of the actual interference or likelihood of interference. I've cited the case of Richard David Allen, already cited. The court must therefore strike a perfect balance to ensure that the trial is not impeded by acts of interference with witnesses, but at the same time uphold the rights of the respondent. This was held in KKK versus Republic 2017 EKLR. The common ground in the Eastern case is as follows: is that the respondent is the officer commanding police station, Central Police Station. That is not in doubt. It can also not be left to doubt that Central Police Station is the scene of crime according to the investigating officer. It is also not indubitable that the respondent is a senior ranking officer in the National Police Service in the rank of the Chief Inspector of Police. It is also not in dispute that the majority of the witnesses, according to the investigating officer, will be police officers who at the time of the commission of the offense were serving under the command of the respondent. Corollary, the respondent will significant influence and or camaraderie with the said witnesses with the likelihood of contacting them, thereby jeopardizing investigation entirely. It is also not controverted that the scene of crime was tampered with, where the CCTV surveillance system installed at the station were interfered with. Cumulatively, having laid down the evidence pointing to the possibility of respondent interfering with the witnesses and investigation, I can sagaciously adjure that the state has credibly and specifically demonstrated the likelihood of such interference. The fears of the applicant that the presence of respondents is likely to have on witnesses is not far-fetched and contrived, based on the Blue Code of Silence, which the Court of Appeal, in the case of Titus Gamao Musila Katitu Supra, ascribed is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. The said court went further to demonstrate incidences where police in Kenya have engaged in practice of covering up for each other. The respondent, having served the police service for donkey years, approximately 29 years, it is ineluctable that he has created the network and the bond with fellow police officers who are likely to cover up for their own by deliberately tampering with the evidence, records, and loss of vital documents. This was demonstrated in the instant case where the DVR power cable was disconnected and the DVR logs changed and formatted. The foregoing argument finds parapet in the decision of R versus Police Constable Samson Muriu Kimbiu, 206 EKLR, Inspector of Police Veronica, another cited case, Inspector of Police Veronica Gitai and another versus Republic 2017 EKLR, and Republic versus Mombi, criminal case number 33 of 2020, which are some of the example of cases where the superior courts have unequivocally expressed concern over police cover-up of crime involving police officers. In the same breath, the IPOA board end-term report May 2020 to May 2018 at page 93 enumerates the following facts, and I quote: in addition, non-cooperation by the service have been concerted efforts by officers to cover up crimes, with official documents and exhibits being tampered with, shoddy and hasty investigation by police to defeat justice, charging in court of victims of police misconduct to circumvent IPOA investigation, skewed interpretation of applicable law to justify police action, poor record keeping and failure to maintain proper record as per the law or maintain proper record as per the law or service standing orders, deliberate records tampering and loss of vital documents, manipulation of arms and ammunition movement register, and serialized and unsealed documents to circumvent justice cause, end of quote. I am therefore satisfied that the prosecution have placed before this court compelling reason to enable me deny the respondent his right to bail or bond at this stage. The investigating officer, Abdirahman Jibril, estimated that they are 49% through with the investigation. Extrapolating from that figure, I direct that the respondent shall be remanded for a period of 15 days to allow the conclusion of investigation.
Much
obliged, Your Honor, and on behalf of the applicant, Your Honor.
Your Honor, probably I can add that now that the court has given 15 days, so we are saying 6 days are over. 6 days are over. It should not have stopped it. It should not. So we are saying 9 days are remaining, and don't even say working days. Any day, Saturday, Sunday, yeah, they've agreed.
nowadays.
You wanted to say something before we started the ruling?
After this, then I'll
Okay.
This is a different subject. You know, to give effect to what my brother Mr. It starts running from the day somebody is in custody. And that is now the position of the law. And therefore, anybody in Amisina's application also gets that favor that from the day he was in custody, the days start running from the day he was in custody. So from Friday, today, those days to be computed to be part of the days that is being detained. That's all.
I join my colleagues in appreciating the court's diligence and studious abilities. You've used very kind words for both counsels, so we return the favor. On the computation of time, IPOA's application was brought before you on 16th. The approximation of 49% was in respect of the date of 16th. So the computation of time, which then the court has used because the court has relied on that benchmark of 49%, reasonably and logically, and because I'm a student of common sense and the law, and commonsensically starts counting from 16. According to us, the counting from 16th, that would also be supported by the fact that the court gave its days in relation to the date of delivery of the ruling. So the most favorable counting, which would otherwise have been from today according to the ruling, then goes to 16th, which is Monday, the date we made our application. That leaves us with 1st of July as the expiry of your 15 days. But I don't think there should be a difficulty in computing time. I know we agree. So, Yona, we will also be humbly praying that you serve us with, you supply us with a copy of the ruling. But I suspect there must have been a slip of the tongue. The ruling must have referred to my learned senior, Mr. Makori, as a Miss Makori. I don't know whether I picked it as well. Oh. So that if we get before we get the copy, it could be a Mr. Where I come from, we take it very seriously. Probably senior didn't take it seriously. Thank you very much.
And it came out as Miss, but in the ruling, it's Mr. Makori. And I apologize for that, and I take it back. It wasn't intentional. I think there was only, in the defense, there was only one lady today, she's missing.
She's in another matter in Machakos. We shall be joining her shortly.
One thing they are forgetting and they're telling you, and which they could not dispute, is that the response to the court statements. One of the things they brought to your attention was the issue of the phone, which we gave them, and it was not disputed.
That was investigations. Unless they are saying those statements are recorded before 16, he was illegally in custody. He was in their hands and they were investigating him. So that's why we are saying from the date of arrest, investigation started when...
To refer you to section 56 and 57 of the Interpretation and General Provisions Act, Cap 2, which has settled the issue of time, which is in consonant with what my and friends are saying.
Unless on the law, anything else you cannot respond.
Sorry, Your Honor, this could be a reference to 49%. It's not disputed. The application on which this 49% is best is brought to you on 16th. As at 16th of June, the IO says we have so far done 49%. It is that baseline that this court has used to say that 21 days where you've done 49% will be on the higher side. Because you've done 49% by 16th, I will add you 15 days. Those 15 days can only be counted on the 16th, which is where we have the baseline of 49%. Your Honor, on my left, there's nobody who passed his mathematics, but I was the best student. I'm sorry, I withdraw.
Not on math.
On a light note, I withdraw.
Withdraw that one.
I withdraw. My Honor, again on a light note, I was the best student in mathematics in 2004 in Kenya. So I'm calculating for them.
The problem is the income. You know, 20%. So if you add 49 to 20%, it's 69. 31% on 7 days or 9 days is sufficient.
Blackmail.
Yeah, so I'll give these directions.
Let
Yeah?
us hear the court.
I'll give these directions. Yes.
I also did very well in
Okay.
I won't say what that's called.
A levels or O levels.
You're only given 21 days to do 51%. So you are telling them that 21 days is a bit on the higher side, but I can give you 15. So the 15 is to do the 51%.
Yes.
So it should be computed from the date they had not done the 51%. That is 16.
Okay. Thank you.
Your Honor, just to add on one thing,
Yes, Mr. Kito.
even if we'll still have a mention so that they can come and report to the Honorable Court, so that if there are some areas that they need to cover, they will still make another application, so there's no prejudice whatsoever from their side. We'll still come back for mention, and if you are for good investigation, we shall deal with the next process, but if it's not, we will make other applications also.
Your main permission, just to be fair, is not here at the moment, but being a counsel as a IPOA, I can confirm concretely that on that 16th is when we were computing the 49%.
Okay.
Yeah, so as far as we are concerned, bringing that application to you, the 21 days was to count from that day onwards.
Okay.
And therefore, with your ruling now, it should actually count from that day.
Okay.
The 49% from the 16th day when the application was before.
Okay. Mr. Shadra.
If you permit, we make the argument with the assumption that the ruling has been made on the 16th. When the ruling has been made, just imagine, we are common law lawyers, so we can take that. So, Your Honor, flowing from the arguments that have been made by my seniors, I think that as we speak already, they have already spent 2 days. Because we came in on the 16th, they have already spent the 2 days. So it doesn't make sense for them now again to make the arguments that you should be looking at things from the 49 based on when they came to you. They have already been doing some certain things. So from that, Your Honor, I beg that I be associated fully and extensively with the arguments made by my seniors and my colleague, Mr. Kiaton.
No, we actually agree with Mr. Wambui.
Let me just give direction, but there's something I want to quote here from Kizito Mihingo in his book, The Meaning of Death. Yeah, Kizito Mihingo, for those who vastly read, yeah, is a Rwandese songwriter. Yeah, and he quotes, yeah, "There's no such thing as a good death, be it by genocide or war, slaughtered in revenge, vanished in an accident or by illness. Those loved ones are praying for us. There is no worse thing than death." End of quote. So the direction I'll give, maybe this is the last time I'm in contact with this matter, because I believe probably investigation will have been concluded and the matter advanced. I sincerely send my condolences to the family of the late teacher and blogger Albert Omondi Ojuang. So kindly, Julius Juma Council, convey the court's deepest sympathies, yeah, and condolences. So in respect to this issue of computation of time, the same will be computed from the 16th of June when the application was filed and lodged before this court. So those who are quick in maths, it takes us to the 1st of July.
1st of July, that's right.
Mr. Dunstan?
Yeah, then
Yes.
I'll do the next application.
Okay.
One I was.
So we've agreed we'll have a mention on the 1st of July. Yes, you can proceed with your...
You to prayer 2
Okay.
and granted access of the phone to IPOA. The handset was taken by the investigator on the date of arrest. Other than the investigator and the owner of the phone, none has access to the operation of that phone. From yesterday, that same number of the OCS, it is number, that same number, Your Honor, the OCS, that's the respondent, 0722 91 9880, has been sending messages soliciting for money. Among the victims is Mr. Cliff Mbeta, who has been asked for 80,000 shillings. Family members who are here, the phone is engaged in looking for money and fundraising that the OCS is in a problem that he requires money, people to fundraise for him. This is a serious issue that if the commissioners of IPOA who are in custody of the handset and the password have allowed that phone and that contact for citizens to be swindled. Custodian of those phones, those are the commissioners of IPOA, be summoned to this court to explain how the phone in their custody You know, remember, it was a and we said we have no problem. IPOA is a constitutional office. But definitely, that is where we are saying, if the state is disputing, we want the commissioners to be present before this court to explain that grievous anomaly. You know, with that, I will allow my other colleagues to proceed. I have another matter before Machakos High Court at 4:30, so that I go and attend. Okay. I be allowed to be discharged.
Okay,
but my able team is able to prosecute that.
All right, thank you.
Thank you.
You want to buttress on that? So, June 2025, whereby you reported all those issues.
Yes, sir.
And what we pray, Your Honor, apart from the summons, is expedited investigations so as to protect the integrity of the investigation, because it goes into the root of all this process. If that phone, gadget, and everything is infiltrated, Your Honor, the integrity of investigations will be jeopardized. And as such, Your Honor, pursuant to that OB and that report, we pray that the investigations be expedited, the investigating officer be summoned to explain, and also on top of those commissioners, Your Honor. We so pray.
The day in case we arrest.
Oh, you received a message also?
Yes, I'm the one who received it.
Okay.
Okay. But one was to me at about 9 p.m. in the night.
Okay.
Probably I might be a witness eventually if we arrest these four people. But then, for the moment, just like everybody is stepping aside, if the people can step aside and deal with a sort of decision. And it's serious.
Of that gadget. That gadget is a subject of investigations by. The moment they are able to use that gadget for other purposes, we don't know what they are doing with it. That may result in an outcome that none of us is in control.
Indeed.
And even the court, whatever the outcome of that investigation, nobody can assure us of the integrity.
Serious allegations have been made, which we are not ready to deny or confirm.
Okay.
We confirm that a phone was taken from the respondent. Considering the nature of those allegations, and having heard what Mr. Langata said last, without the attempt to impugn bad motive on their part, because he's already talking about the integrity of the custody. As we speak now, we believe, and we have no reason to doubt, that the phone and any other exhibit in relation to this matter has been properly kept in safe custody, in line with the dictates of chain of custody. We have quickly, as a preliminary issue, texted Mr. Jibril.
Okay.
He has responded that no one has it switched off and it's in the lab.
Okay.
I have no reason to doubt, just like I have no reason to doubt them, I have no reason to doubt Mr. Jibril, that the phone was switched off immediately it was taken from the respondent, and it is safely kept in custody in a lab. However, Your Honor, we would humbly advise our colleagues through the court that they make a report, because these are serious allegations, so that... Let me just finish. If you've done that, that's okay. That's a good way to deal with it. So that separate investigations can be undertaken on that. But Your Honor, just like I mentioned earlier that I'm a student of common sense and the law, it beats logic that a senior investigator in the level of Mr. Jibril would request for 80,000 using the same phone of the respondent. But because I don't have want to impute bad motive on their part, even though it beats common sense that an investigator can ask you for 80,000 and ask no one else, ask the counsel for the same person. It beats.
There are a number of messages. There's 25,000 for another person. There are quite a number.
That's right. I am saying that.
And also, counsel, we are not imputing.
Let me finish.
We are saying a non-person, not Jibril. We know Jibril is a good man. He's an advocate of right.
Let me finish. What I'm saying, Your Honor, without doubting my colleagues and without doubting the IO, is that it would beat common sense for whoever it is to take, for such a public interest matter, the phone of a respondent in the level of the OCS and request his counsel, among many others, his counsel for 80,000. So we ask them to report. Let us have investigations into that matter, so that the truth may come out. We could have a mention date, if there is need be to bring the investigating officer. I don't think we need the commissioners of IPOA to come and tell us that the investigating officers kept a phone, because operationally it is the investigating officers who are in custody of the mobile phone.
So I think it's a very serious allegation.
Yes.
Ms. Christine.
Yes, Your Honor.
Because already they have undertaken the first step of reporting, yeah? So what we can do, it's been a long night and a long day, yeah? Let's take a mention date, yeah? And then we can summon the investigating officer, Mr. Jibril, yeah, to shed light, because through I understand he is also they should follow up on this, yeah, because as a court we cannot investigate.
That is.
We don't have that.
I have been there for about 8 years, and at no point has any board member or commissioner have access to exhibits. Those are investigative processes, and it doesn't get to the board. And it is on that basis that I humbly ask also for good order and to enable me report back for the necessary reporting to come back to the court. It would be good for us to get the exact timing, the the details of the timing of those messages. He has just given us the number, and Jibril confirms that that number is actually the OCS's number.
Okay.
But we need the timings of those messages, the different content, which maybe you can direct us, like we can do after the court session or now. And lastly, Your Honor, we are alive also to the fact of something called spoofing. I've actually experienced it in another court at some point. This is just sharing for the knowledge of the court and for the media, because it is a very serious allegation before the media. Spoofing is something equivalent to what we call cloning of human beings. So that when you want to issue your phone, I'm not accusing anybody, but I'm just giving us a possible scenario. Before you issue your phone for an investigative process, that spoofing happens. So concurrently, something is happening behind the scene to be seen as if your phone is still active elsewhere, yet it is controlled by a different gadget and even a different SIM card.
Okay.
So since we are alive to that, we take it very seriously, and especially because I've said at no point. In fact, even for me as counsel at IPOA, at no point do I interact with the exhibits. And since we also have a clear chain of custody in terms of paperwork, we can trace from the day it was taken, where it went. We are informed it's in the lab. Paperwork is there. Okay. So allow us that time, whichever way we direct, but for us we need the timings and the full details of those contents.
Yeah, that's what I was suggesting. Let's have a mention.
Yes.
Reach out to Mr. Ombeta and his team, eh?
I don't have his contact. I will not know how to reach him.
So what we can do, we can have a mention and let the IO come, just for the purposes of, because it's a very serious, and very weighty allegation, and you know it's a very sensitive matter, yeah? That is before us, yeah? And we should equally take it with the seriousness that it deserves, yeah? So let's, because it has been raised and it has been reported, yeah? So let's have a mention where now the lead investigating officer, they said Mr. Jibril will come to court only for purposes of confirming, because he's the one in custody of the same phone, yeah?
Yes.
Yeah. So we can agree on a date.
So that, Your Honor, as we agree on the date,
yes.
Remember, Your Honor, the report now has not been made to them. They are the ones who are standing like suspects. So the matter has been reported to Langata Police Station.
Yes.
So Mr. Jibril, at the end, and take a statement.
No, so Jibril, tomorrow or Friday. Let us deal with this, because I have been in the prosecution for now around 12 years, 12 and a half. This matter may not just be about this text. I will not say so much about it. Please summon Mr. Jibril to come tomorrow or Friday. Let him give us an explanation, even as the investigations continue.
I think that's fair enough.
So that you don't make memes about me.
Because it appears like he's looking the way he's looking at me, but
No. Council may not know. Mr. Ombeta knows me well. Friday is okay.
So Friday will be the 20th.
At 8 a.m.?
At 8 a.m. actually.
All right.
Okay.
At 8 a.m. So at noon. At noon?
2 is okay then. 2 is okay.
2?
Yes.
So we'll issue summons to Jibril?
Yes, summons may issue. Could we instead make it 11? I'm told that Jibril may be going to the mosque
for prayers.
We can do 11.
You are my friend, we have no problem. You know, Your Honor, they call him the fraud lawyer. And while they call me Bail and Mr. Omari Bond.
I've not heard of that.
At least you have names.
So once again, I want to thank you for the propriety, the decorum that you've exhibited, and if there's anyone who has been offended by my ruling, it's just a ruling that I've made in my fidelity to the law. Yes. So thank you so much. I wish you a good evening.
Thank you.
Thank you.
At least you understand. I mean,
Today we came to court for the ruling of the respondent OCS Talam in this murder trial, murder investigation for Albert Ojwang. The court has made a decision that the respondent shall be in custody until the 1st of July. The state has also conceded that probably if they finish the investigations earlier, they'll be able to come back to court earlier. We accept the ruling. It was well reasoned. We really have no problem with it. But as a result of that, we have also come under certain other issues that emerged from last night. Yesterday we were in court. We were able to show that the phone that belongs to the OCS had been handed over to the investigating team of IPOA. Mr. Jibril, the investigating person, agreed that he had the phone. It was not contested. We also made an attempt, as the arguments were going on, to give him the number and the access to the phone. Speaking for myself first, at about 9:37 p.m. last night, I received a message from the exact number of the OCS, which has actually been confirmed in court that it is the exact number of the OCS, asking for money, 80,000 shillings. I have the message quite clearly that shows there was a request for 80,000 shillings. I was suspicious of the number because I knew that we had left court and the phone that we were talking about was in the custody of the investigating team. And the message is quite here, it's quite clear for anybody who would want to see it. So I was suspicious and I said this cannot be true because I know the phone has been with the investigating officer. Because of course we believe that there is some integrity and we believe that there are people who are, we should be able to respect that they will keep what they call exhibits and other data that has been collected. But the number is actually the OCS's number. So I indicated to the person that I do not have money right now, probably later, tomorrow, because I had exceeded my limit. It was a way to play around. Today in the morning, the person said, okay, thank you. And today in the morning at about 9, the person again sent me a text asking me good morning. I did not respond because I knew that there was something being played here. I spoke to my colleagues who are here. I had also spoken to Mr. Omari, Mr. Council here, Kiton had also spoken to Mr. Jibril, who had actually apologized, but he will be able to explain that by himself. And the matter, we advised the OCS to report the matter in the station that was being held, which is Langata Police Station, which he reported. There's an obit to that effect. This message did not only come to me. Other family members, as will be told by other councils, have also received the messages that asking for money. While we were wondering why there was a fundraising to that effect, the OCS is actually shocked and has started the process after the report. The court has asked Mr. Jibril to come to court on Friday at 11 a.m. to explain or to talk about or to shed light about it. But in the same breath, we'll be saying that the matter be investigated by Langata Police Station or the DCI in Langata, because in any case, Mr. Jibril, who has the phone, needs to come and explain a few things about it. So he cannot investigate himself in his own matter. So far, that's what we can say.
We are actually surprised the Independent Policing Oversight Authority are the people who are now compromising the integrity of the gadget belonging to our client. Because as my seniors stated that so many people have received messages soliciting for money from our client's mobile phone, and the last time we were before court, it was on record that the said gadget had been handed over to IPOA. So our issue or our question before court was on the integrity of the investigations. Remember, IPOA is an independent unit, and like my senior stated, as the advocates for the suspect, we believe that the outcome of that investigations will be impartiality. But as you have all heard, that we are now complaining that the mobile phone belonging to our client has actually been compromised. So the big question tonight is, what will happen to the entire investigation? If something simple like a mobile phone can be compromised, we don't know who, and we don't want to speculate. My senior has indicated that Jibril, who is the investigating officer at IPOA, is a person of interest. And we will wish to see that he is invited at Langata Police Station to make a statement. But be that as it may, our question or our issue is, what will be the outcome of the entire investigation? Will the public or will the council or will the suspect have, will they believe in that investigation? Because if already something simple as a gadget has been compromised, what will happen to the entire investigation? And remember, this is a very serious case. That is the question we have tonight.
Thank you, thank you.
Yes, currently I can report that the family is working now on burial arrangements for the deceased. And by end of this week, Friday, we should give you a detailed report about when the deceased will be buried and other activities that we are going to be holding both here in Nairobi and up country in Homa Bay towards the burial of the deceased. Today we came to court for the ruling in the matter of the OCS who has been detained, and we are happy with the ruling that has been delivered by the magistrate directing that the OCS be detained for a further 15 days from Monday, so that counts to 13 days from today, to allow IPOA and other investigative agencies to continue and conclude investigations where the OCS is a person of interest. So that is all we have as far as investigations involving the OCS is concerned. We are still waiting to hear from IPOA how far they have gone with the other people that they have informed us are also persons of interest but who are still at large. We are aware that so far 7 people have been arrested and arraigned in various courts, and I think all of them are currently being detained for varied durations to give IPOA time to conclude investigations. We are also aware that there are others out of the 7 that we have been informed that are being pursued, but who are still at large. We hope that they get arrested soon so that this issue of investigations be concluded to enable us know really who was behind this heinous act, so that such person shall stand trial. Thank you.
The compensation of the victim of the violence or the police brutality. And here we have the case of Albert Ojwang. We've heard that President Ruto approached the family and gave a financial support to the family. What is the legality of financial compensation to a murder case?
Well, it is true that the head of state called the family and extended a hand of support to them, just like any other citizen. Because remember, last week the family opened a pay bill number and requested for support to help them defray the funeral and related expenses. And so in that regard, it is true that the head of state extended a hand of help to them. And also Honorable Raila Odinga also extended a hand of help to the family by donating some money. And every other Kenyan is welcome. Now, but it should be understood that that is not compensation. There's a difference between compensation for the heinous death of our friend and any financial support that anybody in their personal capacity can give to that family as at now. So yes, whereas it is true various people, including wananchi wa kawaida, have come up to support the family with various donations, that is not compensation. Compensation is anchored in law. And the family of the deceased and any other family who has, that has lost a member, has lost a kin in the manner similar or closely similar to the manner in which we lost Albert, is free under the law to file a case in the High Court and pursue justice and pursue compensation for the loss of their kin. So that with regard to the case of Albert, we have not reached that point where we say that we are now filing a suit in the court for reparation. No, we have not reached that point yet. But when we finally reach that point, we will definitely do the needful. If the family decides that they want to file a case to seek compensation for them for the loss of their son, definitely they are entitled under the law. And when they give us such instructions, we will file the relevant suit papers. But I repeat that the support that they have received as at now from various people, including the head of state, is not reparation, is not compensation. Ni usaidizi too, because based on the manner of death that the deceased suffered, certainly there will be huge financial resources required.